Well, good evening, everybody. My name is Michael Mofton. I'm the Chief Executive Officer of B'nai B'rith Canada. And thank you to each and every one of you for joining us here tonight for our inaugural event for the Matus Law Society. The Matus Law Society is a newly established law society in honor of David Matus, who's with us here tonight and who I'm pleased to be engaging in a fireside chat with. And David is one of Canada's most renowned and accomplished lawyers and human rights activists. This is an exciting opportunity for Jewish legal professionals to help combat anti-Semitism and to stand up for human rights. Our society is going to function as a primary hub for Jewish members of Canada's legal community. All events are going to be held virtually for the time being. So all Jewish lawyers, paralegals, and law students from across the country can join and participate no matter where they are located. There's all kinds of great benefits for joining up. So please tell your family, tell your friends, tell your lawyer. There's going to be continuing legal education or CPD credits for every province where we have members. So it'll be accredited in regions all the way across the country. You're going to have access to unique networking opportunities with some of the country's most prominent lawyers and activists. There'll be an automatic B'nai B'rith Lodge membership and an ability to get involved with our League for Human Rights on any manner and number of human rights and anti-Semitism files. So it's an extremely exciting opportunity, and we are so proud to launch it here today. I'd first like to just introduce David, and then we're going to jump right into the fireside chat. So David Matus is the Senior Legal Counsel for B'nai B'rith Canada. For over 4 decades, he has practiced law and has long been recognized in Canada and abroad as an authority on human rights, immigration, and refugee law. He has been an advisor and human rights observer for the Canadian government and has been sought out for his expertise by several human rights organizations, such as the Canadian Council for Refugee, the International Commission of Jurists and Rights and Democracy. In recognition of his contributions in the advancement of human rights, in 2008, David was awarded the Order of Canada. David is the author of several books, including No More, The Battle Against Human Rights Violations, Bloody Words, Hate and Free Speech, and Aftershock, Anti-Zionism and Anti-Semitism. Among many marks of distinction, David has had an honorary doctorate from Concordia University. We're honored to have David here tonight. He has worked closely with B'nai B'rith more than 30 years on some of our most important cases, including where we've intervened in the courts. And we'll have an opportunity in the next 30 minutes or so to give you some insights into some of these cases, including major national cases involving B'nai B'rith's highly respected League for Human Rights. Importantly, we'll indicate how your involvement in the Matus Law Society can help us in similar initiatives and legal challenges in the future. We're going to be entering a question and answer period following my discussion with David that will give a chance to explore some other things that have been mentioned and not yet raised. So thank you to all of you who have participated and submitted questions. We're going to be getting the is a big topic area, something B'nai B'rith and yourself have been involved in for many years. Can you tell us, David, about your importance of and story behind our legal interventions and what this group here can strive to accomplish on the subject?
Sure. I first got involved in 1981, and it was actually through a Canadian Jewish chair a war crimes committee and write a report on how Nazi war criminals in Canada could be brought to justice. And I wrote the report, but before the report was released, the presidency and priorities of Congress shifted. So with the permission of Congress, I took the report to B'nai B'rith Canada on the invitation of B'nai B'rith and released the report in 1983 through this organization. The government of Canada appointed a commission of inquiry on war criminals shortly afterwards in 1985 under the chairmanship of Justice Jules Deschênes. The League for Human Rights of B'nai B'rith Canada applied for standing, was granted standing, was the first organization to do so. I attended every public hearing on behalf of the organization, and even with B'nai B'rith took the commission to court successfully in 1986 for failing to disclose to us legal opinions for which the commission had contracted. The commission report recommended various remedies for bringing Nazi war criminals in Canada to justice. And so that was the initial stages of how I got involved in this issue.
So what happened after the commission report, David?
The commission recommended a number of remedies, and the government chose only one, prosecution, which unfortunately ran aground in the case of Imre Finta. Finta was accused by Canadian prosecutors of being a key official in the rounding up of the Jews of Szeged, Hungary in 1944. He was in charge of the rounding up Jews Auschwitz and to Strashof, a concentration camp. He was accused of all this and didn't call any evidence on his own behalf, but relied on legal defenses alone. Counsel for Finta claimed that Finta was not guilty because Finta thought Jews were the enemy. The issue became it was a jury trial, and the issue for the judge was whether this defense could be put to the jury. The judge said yes, it could, and Finta was acquitted. So the issue became for the courts above whether the judge was right in putting that defense allowing that defense to go to the jury. And Ontario Court of Appeal, Supreme Court of Canada, both said yes and split decisions. B'nai B'rith intervened in a case at the level of Supreme Court of Canada in 1994, but to no avail. The effect of allowing his belief that Jews were the enemy to be put to the jury meant that anti-Semitism became a defense of the Holocaust and that racial prejudice became a defense to genocide. So the Canadian law on war crimes became useless. Had violated the American Declaration of Rights and Duties of Man. But a formal decision became unnecessary on this petition because of new Canadian legislation, Crimes Against Humanity and War Crimes Act, and a decision of the Supreme Court of Canada in the case of Leon Mugesera. The new legislation enacted to implement the obligations of Canada under the Treaty for the International Criminal Court had a specific clause repealing the Finta defense of racial prejudice. And B'nai B'rith Canada had made submissions to Parliament before the legislation was enacted about that issue. Leon Mugesera was ordered deported from Canada for incitement to genocide in Rwanda. His case went to the Supreme Court of Canada, where B'nai B'rith intervened and I acted for them. The court, in that judgment, in the reasoning about the Mugesera case, stated that the case of Finta and this particular defense, which I just addressed, should no longer be followed. The new Crimes Against Humanity and War Crimes law was actually used later in the case of Desiree Munyaneza, a Rwandan genocidaire who was convicted in 2009. And that was the immediate aftermath of that Deschênes Commission report.
Were there any criminal prosecutions of Nazi war criminals after that point, David?
No, there weren't. The law became unusable because of the Finta case, and when it was eventually amended and became usable again and used in the Munyaneza case, it was too late. Canada had already switched to revocation of citizenship and deportation for those who hid their Nazi past on entry. This remedy was better than prosecution in the sense that there were successes in court. However, the remedy suffered from another defect, that it was so fragmented that it became impossible to go from start to finish against anyone who wanted to litigate every step of the way. Revocation of citizenship required a cabinet decision. The cabinet had decided that two persons accused of Nazi war crimes who had lost in court on the issue of whether they lied on entry, Katrick and Odinsky, could stay in Canada. B'nai B'rith challenged that decision of the cabinet in court for those two people. The court held we had standing to do that, but also held in 2010 that the cabinet was free to do what it wanted. Oberlander is a case which began in 1995, and he also lost on court on the issue of whether he hid his Nazi past on entry, and the cabinet revoked his citizenship. However, he kept on challenging one cabinet decision after another on a variety of technical grounds successfully. After the fourth cabinet decision and the fourth challenge, B'nai B'rith intervened, and finally in 2018, on his fourth challenge, the court upheld the cabinet revocation decision. But 3 years later, and 26 years after the case began, Oberlander is still here. So that was the subsequent aftermath.
Yeah, and B'nai B'rith just put out a press release on Oberlander just about a week or two ago. But what do we learn from all of this, David?
Well, I would say, like the defective criminal law, Parliament changed the law, learning from the Nazi war criminal experience, amended the citizenship and immigration laws, which allowed endless litigation to delay removal indefinitely, and telescope procedures. B'nai B'rith made submissions to Parliament about these laws. However, the cases already in the pipeline were grandfathered, meaning that the Oberlander case could continue his litigation. There was a number of people involved with me in these activities. Marvin Kurz, who's now a judge, as well as Susan Sherendorf and Kenneth Narby. And I would say generally what we've learned is that perpetrators seek immunity. The challenge we continue to face is to get the right laws in place and make them workable. It was really too late and too overwhelming a task to get justice to reach all the Nazi war criminals who came to Canada. But changes in the law have made the system a lot more workable to bring to justice later mass murderers and their accomplices.
Great. Well, maybe if we can shift over to hate speech, David. Can you tell us a bit about your history with the League for Human Rights, with B'nai B'rith on the subject of hate speech, and the importance of and story behind some of our legal interventions, and what this group, which is now in your namesake, what can they strive to accomplish on the subject of hate speech?
Hate speech is a continuing issue. We have had in the criminal code for some time now a prohibition against incitement to hatred, and it sat unused for many years. And then eventually there was a prosecution of James Keekstra, a high school teacher who was basically teaching his high school students about the evils of Jews, and he was prosecuted and convicted, and the issue became the constitutionality of the law under which he was convicted. And the Supreme Court of Canada held that the law was constitutional in a split decision. B'nai B'rith intervened. John Ross Taylor, in a case the same year in the Supreme Court of Canada, brought into constitutional question the civil law on hate speech. The Canadian Human Rights Act used to have a provision, it's now repealed, which said that they could issue an order against someone to stop promoting hatred through the telephone. And what Taylor was doing is he had a pre-recorded message, anti-Semitic message, and he gave out cards with the telephone number on it, and the commission issued an order against him. He continued. He was convicted of contempt of court. He appealed his contempt of court conviction to the Supreme Court of Canada, and the court found it constitutional. There was then the case of Malcolm Ross, and well, even before that, there was a case of Ernst Zundel. Ernst Zundel was a Holocaust denier, and his case was in 1992. The government prosecutors were initially reluctant to prosecute him, and it started off as a private prosecution, and then the government took it over, and he was prosecuted for violating the criminal code provision on publishing statements he knew to be false, the false news provision. B'nai B'rith intervened on that as well, Supreme Court of Canada, and the case, the provision was held unconstitutional. Malcolm Ross in 1996, it was another case that went to Supreme Court of Canada where B'nai B'rith intervened. Malcolm Ross was also a high school teacher promoting anti-Semitism, but he didn't do it in the schools. He did it out of the schools. The apparent complaint to the New Brunswick Human Rights Commission. The Human Rights Commission found that his employment created a climate of hostility in the school and ordered his employment to a non-teaching position. He went to the Supreme Court of Canada on that, and B'nai B'rith intervened, and the court held that the order of the Human Rights Commission, that particular order, was valid. I was involved in these cases, but so were other lawyers, Mark Sandler, Marvin Kurz, Jackie Cheek. These cases raised questions of competing rights, the right to freedom of expression, the right to freedom from incitement to hatred. And where the balance lies in these rights is a continuing issue, continually popping up, a never-ending issue, which B'nai B'rith continues to face in a variety of cases.
Yeah, and fast forward a few years, and now we're convening this fireside chat online, and hate on the internet just seems to have exploded in recent years. So what could a group like this, what can the Métis Law Society hope to achieve in combating this new form of racism and hatred, and not just anti-Semitism, but this general polarization on hate on the internet?
A new form of propagating hatred requires new responses. There was actually a provision in the Canadian Human Rights Act dealing specifically with hate on the internet. It was a variation or an amendment to the provision under which John Ross Taylor was brought to court. Taylor was using telephone, and there was a telecommunication provision in the Canadian Human Rights Act. In 2001, that was amended to include communication on the internet. That case and the subsequent case law about it did generate some problems, and there was some use to it as well. We ourselves used that provision in the Canadian Human Rights Act against the Manitoba Knights of the Ku Klux Klan in 1992, against the Aryan Nations of Alberta in 1989. In 1998, we intervened in the Supreme Court of Canada in the case of LibertyNet, and the court there held that the Canadian Human Rights Commission had the authority to issue an interlocutory injunction prohibiting the communication of messages which were the object of a complaint until a human rights tribunal decided on the merits of the complaint. And so that was the side on which we'd intervene. And the law, at least from one perspective, was working, but from another perspective, not so much. We ourselves, B'nai B'rith, was a target of complaint in Manitoba in 2004 to the Manitoba Human Rights Commission based on a rumor of what an invited speaker had said at a meeting we had hosted for law enforcement officials. The complaint was eventually dismissed at a preliminary stage for lack of evidence, but this preliminary investigation took almost 5 years before the complaint was dismissed. We did make a specific effort related to the internet in 1998 in BC. We had asked BC Tel to deny internet connectivity to an internet provider, Fairview, because Fairview had been hosting a wide variety of neo-Nazi organizations. It became the go-to site for neo-Nazi organizations. BC Tel didn't do what we asked, but did ask Fairview, when their contract came up for renewal, to commit to indemnification to BC Tel for any liability BC Tel might incur from the hosting by Fairview. Fairview, rather than do that, did not renew the contract. Well, now there hasn't been a law since 2013, because in 2013, the internet provision enacted in 2001 was repealed, as well as the whole telecommunications provision, partly because of the problems with the lack of procedural safeguards. And at the time of the repeal of the old law, we made submissions about what a revised law should contain. And now the government is proposing to enact a new law about hate on the internet. And presumably, once that comes out, we'll have something to say about it. I should say in all these efforts, there were lawyers on staff that were very active in helping yourself and Anita Bromberg.
So, and David, you know, we all know what's going on. We see unfortunately, there's still a lot of hate that's out there in society, but in particular, there's still discrimination against Jews. A lot of the lawyers that had approached B'nai B'rith and asking us to create for the first time an activist Jewish Lawyers Society were complaining about that. Can you talk a little bit about maybe some cases that were direct discrimination against Jews, and what a group like ours can do to help combat, unfortunately, this trend which is still out there?
Yes, there have been some cases where we've been involved and give us some precedents which we can rely on. One was the case of Andrew Liebman. He was a Jewish member of the Canadian Armed Forces. He was denied the position as executive assistant to the commander of the Canadian Task Force in the Middle East because he was Jewish. The Federal Court of Appeal in 2001 granted Liebman a declaration that the refusal to select him as executive assistant because of his religion was unconstitutional. And it was Liebman, of course, who brought the case, but we intervened on his behalf. B'nai B'rith also intervened in the case of Amsalem in the Supreme Court of Canada. At issue there was whether Orthodox Jewish members of a condominium in Montreal could set up sukkahs on their balconies. Sukkahs, as you know, are huts in which Orthodox Jews live during a 9-day Jewish fall festival.
Not just Orthodox.
The syndicate, yes, okay. The syndicate of condominium co-owners requested from the courts an injunction prohibiting the setting up of these sukkahs on the condominium balconies. The Supreme Court denied the injunction requested, and again, we intervened in that case. In the Amsalem case, I was assisted by Steve Slimovich. B'nai B'rith is also actively involved in encouraging the application of the definition of anti-Semitism adopted by the International Holocaust Remembrance Alliance. I myself have been involved with the Alliance from the get-go as a B'nai B'rith delegate or representative, starting from 2000 in Stockholm, the founding meeting. And I'm currently now a member of the Canadian delegation to the Alliance, also known by its acronym IRA.
Yeah, so it's interesting, David, because you're mentioning IRA, and we all know that there's an IRA definition of anti-Semitism, and that includes instances of anti-Zionism that cross the line into anti-Semitism. Can you tell us a bit of history with B'nai B'rith on the subject of anti-Zionism? Have there been any legal interventions by B'nai B'rith in that regard, and how can this group also help to fight this, when it crosses the line across from anti-Zionism into straight, anti-Semitism, Jew hatred?
Yes, there was a case which, in fact, is still going on that deals with this issue in relation to Israel and anti-Zionism. There's a case of Kattenberg in the federal court. In that case, David Kattenberg asked the Canadian Food Inspections Agency that wines produced by Israelis in a part of the West Bank controlled by Israel under the terms of an agreement with the Palestinian Authority not be labeled products of Israel. The Federal Court of Canada in 2019 agreed with Kattenberg that label was misleading. The government has appealed this decision to the Federal Court of Appeal, and that appeal is still pending. Just this last December, we made a submission to retired Supreme Court of Canada Judge Thomas Cromwell, who was asked to review the University of Toronto search committee process for a new director of the International Human Rights Program. The reason for our submission was that the person recommended by the search committee but not hired was Valentina Azarova. The research, writing and speaking of Azarova has focused primarily on arguing that the State of Israel has systematically committed gross violations of international human rights. Our submission is posted on B'nai B'rith Canada website, and obviously submissions like that can be made when the situations arise. Now, here too, there was others involved. Aidan Fishman was assisting in the Kattenberg case, and Sarah Teach was assisting in the Azarova submission.
And now, of course, B'nai B'rith, as part of the long history, as you know, we stand for many human rights issues, and not just those that are involving Jewish victims of discrimination. Can you talk a little bit about some of those maybe broader cases that don't involve Jewish victims?
Sure. Well, I'd already mentioned the case of Leon Mugesera, Rwandan genocidaire, the 2005 case. I'd mentioned it because of its overruling of the Finta reasoning on motive, but and superior orders. But of course, that was a non-Jewish case. Another three cases where we intervened were Kremowski, Watcott, and Ward. In Kremowski, a trial judge acquitted several accused of willful promotion of hatred against Roma. The accused had demonstrated with anti-Gypsy signs in front of a motel housing Roma refugees. The judge refused to take judicial notice that the terms Gypsy and Roma were interchangeable. The Supreme Court of Canada overturned that acquittal and ordered new trials. That was a second type of case where we intervened. Third was Watcott. In the case of Watcott, a Saskatchewan Human Rights Tribunal found that 4 flyers violated the Saskatchewan Human Rights Code as exposing persons to hatred or ridicule based on sexual orientation. The Supreme Court of Canada held the provision about hatred in the Saskatchewan law constitutional and the provision about ridicule unconstitutional. The court severed the unconstitutional provision and upheld the tribunal decision on 2 of the 4 flyers. And again, B'nai B'rith was involved. In the case of Ward, this is a recent case. It's just argued this month in the Supreme Court of Canada. A Quebec Human Rights Tribunal found that what comedian Mike Ward said in his comedy routine about Jeremy Gabriel, a handicapped person, amounted to discrimination and a violation of the Quebec Charter of Human Rights and Freedoms. The legality of that finding came before the Supreme Court of Canada 1 week ago today. Our submission consisted of indicating criteria for determining when comedy can amount to discrimination, drawing on the Jewish experience and the jurisprudence in France, Belgium, and the European Court of Human Rights, addressing the defense of comedy used by Mabala Diodani in his attacks on Jews. Now, because of the internet age, our oral intervention and the whole legal argument before the court can be viewed on the court website. The court has reserved judgment. Again, it wasn't only me involved in all of this. Marvin Kurz and Stephen Klein argued the Kremowski case. Marvin Kurz argued the Watcott case, and the Ward case, there was Sarah Teach and I. Now, these cases, I would say, manifest the permeability of human rights violations and the universality of human rights standards. B'nai B'rith hosted on Human Rights Day last year, December 10th, a couple of months ago, a panel discussion in which I participated on the human rights tragedy of the Uyghur Muslims. The interrelationship in victimization continues. The human rights effort of B'nai B'rith has to be global, a general human rights effort. So that's the way I would answer that question.
Yeah, no, thank you, David. And of course, for all of you who are watching here, this evening. Thanks for watching it. That's going to end the fireside chat. We did receive a number of questions from you, and I'm going to be answering them. If you can hand them to me one by one. But again, for those of you who are watching tonight, if you're a legal professional of any sort, please join the Matus Law Society. Have an impact, make a difference. That's what this group is all about. We plan to be activists, as David just mentioned. There's all sorts of incredible things that can be done using the laws of this country to improve the human rights situation, not only for our own community, but for others. And that's really what we want to achieve, all of us together. So anyone, anywhere across the country, and of course, law students too, you're more than welcome to join. Or if you know someone who's a law student, please encourage them and let them know about the Matus Law Society. So we have a little bit of time for some questions. The first one here, David, what drew you to human rights law in the first place?
I was, from a very early age, committed to doing something about the Holocaust. I was born during the Holocaust, but by the time I'd grown up, it was too late to do something directly about it. But what I was trying to do was to learn lessons from the Holocaust and act on those lessons. And human rights struck me as a vehicle that allowed me to do that. One can connect the whole human rights consciousness and the human rights instruments and mechanisms as a reaction to the Holocaust. I mean, they all immediately followed the Holocaust. The initial ones: Universal Declaration of Human Rights, 48, Genocide Convention, 51, Refugee Convention, 51, and the subsequent instruments, and there are many, were basically elaborations of these earlier instruments. The Geneva Conventions on the Laws of War, also 48. So the these instruments themselves were a legacy of the Holocaust, and using them and applying them became a way of acting on my own desire to build up or try to contribute to a legacy from the Holocaust.
Thank you, David. Okay, our next question here. Given the range of your experience in human rights law, can you say that things have progressed where fighting anti-Semitism is concerned? And if not, why not?
Well, anti-Semitism is a constant, and the racial hatred is a constant, and hatred is a constant. I mean, what you're dealing with basically is with human emotions, and the human emotions, the human personality doesn't change. We have seen anti-Semitism since time immemorial, since the days of the Jews in Egypt at the time of the pharaohs, and it has survived the Holocaust. So it hasn't disappeared, but it fluctuates in intensity. And what changes, I would say, is not so much humanity as technology. And what we see with the development of technology is both progress and retrogression, because with technology, we can do things better, but unfortunately, technology in the wrong hands makes things worse. And when you look at the Holocaust, it wasn't the anti-Semitism what was new. What was new is the radio, which allowed propagation of hatred. It was the poison gases. It was the trains. It was the modernization. And we see that problem today. I mean, you asked about the internet. Obviously, we didn't have to combat hate on the internet decades ago, but we do now. Which to a certain extent makes things worse. But on the other hand, it gives us an opportunity to make things better, because we couldn't be doing this conversation today without the internet. So I would say, well, like Charles Dickens once said in The Tale of Two Cities, every single day we are in the best of times and the worst of times, because with technology, things keep on getting both better and worse.
It's quite true. So this question is from Susan. How can the plethora of toxic anti-Israel myths and misinformation abounding everywhere, from peer-reviewed academic publications to Wikipedia to mainstream media, be effectively addressed? Do you have any key principles or strategies to share for those interested in advocacy work?
Yes, well, I would say generally with advocacy work, this is, we're talking about the law, and certainly the law is definitely one way to do it. But I would say that advocacy work isn't only legal work, far from it. If it's left to the lawyers alone, we're in big trouble. Not because of a problem with lawyers, but because human rights has to be everybody's work, and it has to permeate humanity generally. And I would say the way to do it is for everybody with their own skills, with their own networks, with their own aptitudes and interests, convey their convictions and their advocacy. It can be done through art, it can be done through music, it can be done through simply talking to your friends. I would say there's no one way to do it, and what's more, people in different professions are going to have different techniques for doing it. I mean, I can tell you how lawyers can do it, but I'm not the person to ask about how artists can do it. I would say that don't think about this as a specialization. Think about this as something anybody can do in their day-to-day life.
Yeah, that's an excellent point, David. And but of course, bringing it back into the Matus Law Society, I guess there are more ways that we can get involved, even as legal professionals and non-legal professionals as well. For example, you've testified on a number of proposed legislative reforms before the federal government, various committees, the Human Rights Committee, the Justice Committee, on a number of matters. There's more than one way, as you stated, to deal with this, and isn't changing sometimes the law if we have difficulties with the law, if human rights isn't addressed properly, is that an approach that we should be going in as well?
Sure. I would say the law, like many other avenues of human activity, can be a force for good and a force for harm. If you look at the way the law was used in the Nazi period, it was used as a form of oppression or apartheid in South Africa and so on. And I think we have to think about the law as not always potentially being a force for good and a way in which we can make things better. Sometimes we have to get involved in the law just to prevent it from being as bad as it as it might turn out to be. The law is a terrain of engagement, but I think what we're looking for in the law and even outside the law is justice. And obviously, the law is a vehicle for justice, but even with justice, I would say it can't just be a legal specialty. If I may quote an ancient Greek philosopher from BCE times, Solon, he says, "How do we get justice? We will get justice when people who are not affected feel injustice as much as people who are." And I think we have to get that message across, that there's a prior question about Israel, that how do we get concerns about Israel addressed? I think we will get concerns about Israel addressed when people who are not Jewish feel as concerned about this injustice towards Israel as people who are Jewish.
Yeah, there may be a time in the future where people hear expressions BCE and wonder how a term like that might not mean coronavirus for the C. So let's what the next. This is from Esty, and she states that she represents a small group of Jewish Canadian citizens who are very perturbed by the new federal attitude and atmosphere we're feeling towards the COVID pandemic, that there are border closures that have cut us off from seeing our family. There are life cycle events such as births of grandchildren and family deaths, which have been interrupted because of coronavirus. But more than that we are disturbed by what we feel that our legal rights to travel have been taken away. There are new COVID hotels, obviously, and there are some serious concerns about vaccination rollouts. But the question is asking from a legal standpoint, asking about house arrest for individuals who feel they may have not done nothing wrong or illegal, that this is put under the guise of safety, but there's little data to uphold it. Can you weigh in on this constitutional breach, and I guess whether or not this is a constitutional breach, and can you think that anything can be done in these times?
Well, my approach to COVID in the context of B'nai B'rith and human rights and anti-Semitism is that, sure, it has an impact, and yes, something can be done. What we see because of COVID is a change in the form of anti-Semitism. And indeed, if you look at anti-Semitism through the centuries and millennia, what you see is that it's a shape-shifting monster, that the vocabulary shifts. There's the constancy of targeting the Jews, but different reasons, different means. And with COVID, what we see is Jews being blamed for COVID, for spreading it, from profiteering from it, or somehow being responsible or taking advantage. And obviously that wouldn't, though that form of anti-Semitism wouldn't have happened before COVID. We also see a weakened capacity to deal with it, that we can't have the meetings, the conferences, the sort of communications to combat anti-Semitism that we used to have. When it comes to the Holocaust, we've seen a lot of Holocaust survivors who are very important teaching about the Holocaust, elderly being affected by COVID. We've seen a lot of museums, almost everywhere, the Jewish museums, Holocaust museums being closed because of COVID. I mean, the problems that the Jewish community faces because of COVID are not unique. I would say minority communities generally face these sorts of problems, but because the Jewish community is so heavily impacted by racial prejudice and such a great need to combat it, it does have COVID does have a great effect. And the question is, how do you deal with it? Well, I think, first of all, we have to take cognizance of the problem. And secondly, we have to engage in compensatory mechanisms for instance, when it comes to museums and memorials, and we could do a lot more online than we are doing. And a lot of the sites and museums that were physical entities don't much have electronic sophistication, and maybe we can help them with that. And I think, like everything else with COVID, we're living in a new era, and we have to think about how we can adapt to this new era, because with COVID, we've got something which is very old, a pandemic, but we've also got something which is very new, the internet, as a way of which to deal with it. And so I think we have to think about how we can use the tools that are presently at our disposal to deal with the situation.
Okay. Do we have any more questions? Are there others, or that's it? Okay. Okay. Well, we got to cut it off. We got to run. But so, you know what, David, if I'm going to ask you if you could limit maybe to just 2 minutes on this question here. As B'nai B'rith's representative on IRA, can you explain what are the most important, but also the least well understood aspects of the IRA definition of anti-Semitism?
Our definition of anti-Semitism is much criticized as somehow inhibiting criticism of Israel, which it doesn't do. What is concerned about is double standards, accusing Israel of crimes it didn't commit. as I said before, we see anti-Semitism taking a number of different forms, and one of them is demonization of Israel, and then demonization of the Jewish people as presumed supporters of this supposedly demon state. And so the IRA definition is aimed at that and not at criticism of Israel. Another issue is that it shouldn't be law, that it and yet the IRA definition on its website, the definition that IRA adopted says it's not legally binding, and so that's a misunderstanding as well. There's I would say some criticism that it was meant for statistical purposes only and not for combating anti-Semitism, which is not true for IRA. I mean, it was true for some, obviously, some agencies have used it for statistical purposes, but IRA meant it as a means of combating anti-Semitism. There's the question about the examples, and I point out that what the definition is referred to is as a working definition. It's meant to be a set of guidelines, not a rigid framework. That it's not meant to be a statute, even in terms of it's being legally binding, or in terms of it's being, this is it and that's it. And so if it's used with an understanding of what it was meant to be, if it's used purposefully, in my view, it is a useful and important tool for all agencies dealing with anti-Semitism.
Well, thank you, David, and thank you for all of that. Thank you for speaking to all of us here today. I know we have a few more questions, but unfortunately, I think we've run out of time. But we would love to hear from you. So please, if you enjoyed the event this evening, if you'd like to hear more of events like this, please give us the feedback, let us know. But we are so thrilled to have launched the Matus Law Society. Many lawyers and law students from across the country have already joined. And if you haven't yet, please join us, because we want to have an activist society with networking opportunities, CPD, CLE, accredited in provinces all the way across the country, or wherever we may have individuals that sign up. And we want to have an impact and be helpful in the cause of human rights on behalf of our community. So David, once again, thank you for everything you've contributed so far, and all of your, the contributions that are yet to come. We're very, very excited about this, and I know you are too. And please tell your family and friends, join us, and let's be a strong community fighting for human rights.
Thank you.
Okay. Take care, everybody. Thank you.